Hey everyone, and welcome back to the Paralegal channel. Today, we're tackling a topic that can cause a massive headache for so many people. Buying a used car that turns out to be a lemon. You've spent your hard-earned cash, and within weeks, maybe even days, it's clear something is seriously wrong. What are your rights? What can you actually do about it? Well, if you're in the UK, you have more power than you might think. Let's get into it. First, let's look at where these problems usually come from. We're talking about everything from traditional car dealerships and those giant car supermarkets to the new wave of online car retailers. No matter where you bought it, the problems are often depressingly similar. We see things like sudden engine problems, catastrophic gearbox failures, warning lights that pop up on the dashboard like a Christmas tree, and all sorts of broken electrics, from windows that won't go down to a sat-nav that's completely given up. Even worse is discovering undisclosed damage from a previous accident that the seller conveniently forgot to mention. It's frustrating, it's expensive, and it feels incredibly unfair. But here's the good news. There's a powerful piece of legislation on your side. The Consumer Rights Act of 2015. This is your shield. This law states that any car you buy from a trader must meet 3 key criteria. First, it must be of satisfactory quality. This is a bit of a broad term, but it considers things like the car's age, mileage, and price. A 10-year-old car with 100,000 miles on the clock won't be expected to be perfect, but it should still be roadworthy and free from major, undisclosed faults. The engine shouldn't blow up on your way home. Second, the car must be fit for purpose. This one's pretty straightforward. A car's main purpose is to be driven safely and reliably from A to B. If it can't do that because of a recurring fault, it's not fit for purpose. This also applies if you told the dealer you needed the car for a specific reason, like towing a caravan, and they assured you it was suitable when it actually isn't. And third, the car must be as described. This means everything the dealer told you, and everything written in the advert, must be true. If the AD said it had a full service history, it must have one. If it was described as having air conditioning and satellite navigation, those features must be present and working. Any discrepancy between the description and the reality is a breach of your rights. Remember, this applies to verbal claims as well as written ones, though verbal claims can be harder to prove. So, knowing these criteria is great, but what does it mean in practice? Let's break down the timelines because they are absolutely crucial. This is where your power really lies. You have what's known as the short-term right to reject. For the first 30 days after you take ownership of the car, if you discover a fault that was likely there when you bought it, you have the right to reject the car and claim a full refund. The dealer can't force you to accept a repair or a replacement. You can simply say, "The car is not of satisfactory quality, and I am exercising my short-term right to reject it for a full refund." The burden of proof is on the dealer to prove the fault was on there when they sold it to you, which is very difficult for them to do. Now, what happens if a fault appears after that initial 30-day window? Let's say you're on day 35, or maybe 3 months down the line. Between 30 days and 6 months, your rights change slightly, but they're still very strong. During this period, you have the right to a repair or a replacement at the dealer's expense. You must give the dealer one opportunity to fix the problem. The choice between a repair or a replacement is technically yours, unless one option is impossible or disproportionately expensive for the dealer compared to the other. Crucially, during this 6-month period, the law is still on your side. It's assumed that the fault was present at the time of sale unless the dealer can prove otherwise. They can't just say it was fine when it left our forecourt. The responsibility is on them too. Show the problem didn't exist when you bought it, so you've given them a chance to repair the car. What if the repair doesn't work? What if the fault comes back, or they cause another issue while trying to fix the first one? This is where your final right to reject comes into play. If that one attempt at a repair fails, or if they can't provide a suitable replacement, you are now entitled to reject the car and get a refund. Because you've had some use of the car for more than 30 days, the dealer may be able to make a reasonable deduction from the refund for the mileage you've covered, but they can't just pluck a figure out of thin air. It has to be fair. So, you've found a fault. What's the first step? Panic. Shout at the dealer over the phone. No, the key is to be calm, professional, and methodical. The very first thing you must do is stop driving the car if the fault is serious and could cause more damage or is a safety risk. Then, you need to contact the dealer. And my number one piece of advice here is, put it in writing. Start with an email or even a recorded delivery letter. A phone call is fine for an initial contact, but you need a paper trail. You can't prove what was said in a phone call. In your written communication, be clear and concise. State what the fault is, when you discovered it, and what you want to happen next. Most importantly, explicitly state your rights under the Consumer Rights Act 2015. For example, if it's within 30 days, you would write something like, "I am writing to you regarding the Ford Fiesta, registration number AB1 to CDE, which I purchased on the 1st of the month. On the 15th, the engine management light came on, and the car is now running poorly. As the car is not of satisfactory quality, and this has occurred within 30 days of purchase, I am exercising my short-term right to reject the vehicle and request a full refund of the purchase price." If it's after 30 days, but within 6 months, your email would be slightly different. Under the Consumer Rights Act 2015, I am requesting that you repair the vehicle at your expense. Please let me know when you can book the car in to diagnose and rectify this issue. Using this specific language shows the dealer that you know your rights and you are serious. Many dealerships will become much more cooperative once they realize you understand the law. They don't want the hassle of a protracted dispute. But what if they ignore you, refuse to help, or try to fob you off? What if they say it, wear and tear, or you bought it, sold as seen? By the way, sold as seen has no legal standing for a car sold by a trader. It's a meaningless phrase designed to put you off. If they won't play ball, it's time to escalate. Your next step is to raise a formal complaint with an alternative dispute resolution or a DR provider. For the motor industry, the main one is the Motor Ombudsman. They are an independent body that can look at your case and make a decision. Their service is free for consumers, and if they rule in your favor, the dealership is usually bound by their decision. You'll need to provide all your evidence: the original advert, the sales invoice, your written communication with the dealer, and any evidence of the fault, like a report from an independent garage. Another avenue is trading standards. While they don't typically take on individual cases, they collect information about traders who are consistently breaking the law. Reporting a dodgy dealer to them helps build a case against the company and can prevent others from being ripped off in the future. It adds pressure on the business to act correctly. If all else fails, and we're talking about a situation where the dealer is completely unresponsive or has refused to comply with the Ombudsman's decision, your final resort is the small claims court. This might sound intimidating, but for claims up to £10,000 in England and Wales, it's a process designed to be used without needing an expensive solicitor. You can file your claim online, and it often prompts the dealer to finally settle the dispute before it ever gets to a hearing. The threat of court action is a powerful motivator. To recap the action plan: 1. Contact the dealer in writing as soon as you find a fault. 2. Clearly state your rights under the Consumer Rights Act 2015 and what you want them to do: refund, repair, or replace. 3. Give them a reasonable time frame to respond. And 4. If they fail to act, escalate your complaint to the Motor Ombudsman, report them to trading standards, and, if necessary, begin proceedings in the small claims court. Buying a used car should be an exciting experience, not the start of a nightmare. By understanding your rights and following these steps, you can turn a bad situation around and hold dealers accountable. Don't be intimidated and don't give up. The law is on your side. Thanks so much for watching. I hope this has been genuinely helpful. If it has, please give this video a thumbs up and consider subscribing for more content that helps you be a smarter, more empowered consumer. If you've had an experience like this, share it in the comments below. You never know who it might help. Stay safe out there, and I'll see you in the next one. There is a link to our website in the text below.